Mary Day, we have 37 already.
Okay, looks good. Okay. Let me start. Okay. Good evening, everyone, and welcome to our Zoom gathering focused on the International Criminal Court. I'm Mary Day Kent. I'm here on behalf of the United Nations Association of Greater Philadelphia, and I'm really looking forward to this panel. I think many of us have the feeling that I have, which is that we're in politics that are chaotic and simplistic and inaccurate. And I think our panelists this evening will be the opposite of that. The people that we'll be hearing from are, in a way, hardworking heroes of the search for international justice. The United Nations Association for the last few years has celebrated July 17th, which is the day that the Rome Statute inaugurating the International Criminal Court was signed. It's the International Day of International Justice. And many years we've had an outdoor garden party celebrating this. Today we're on Zoom. It's a little hot for a garden party, but this is, instead of the garden party, we get to involve people from a wider range of space and benefit from speakers who wouldn't necessarily be able to reach us. I am very happy to thank our co-sponsors, the Coalition for Peace Action and the Philadelphia Bar Association, that have communicated and provided us with the support to make this possible. And I'm very glad to introduce our coordinator, moderator for this evening, Lana Ulrich, who is a member of the UN Association. She is an attorney based in Philadelphia. She is the Vice President of Content and Senior Counsel at the National Constitution Center here in Philadelphia, but she's participating in her personal capacity. And I am now going to hand over the logistics to her. Thank you, Lana.
Great. Well, thank you, Mary Day, and thanks to everyone here for joining us this evening for this webinar discussion of the International Criminal Court at this critical time for global peace and security. We have with us a panel of leading international law experts who will discuss the genesis and history of the court, its impact, successes, and challenges since its creation, and where the court might be headed in the future. Throughout the program, please send us your questions via the chat below, and we will try to address as many as we can. We'll also be sharing out as many relevant links as we can where you can find out more information about the topics that are being discussed this evening. Now I'd like to introduce our panelists. Enid Adler is an attorney and has served as a representative from 1998 to the present of the Philadelphia Bar Association, to the NGO Coalition for the International Criminal Court, and the Washington Working Group for the ICC. Roger Clark is Board of Governors Professor Emeritus at Rutgers University at Camden School of Law and served on the drafting committee of the International Criminal Court Treaty. Elizabeth Evanson is International Justice Director of Human Rights Watch and former Secretariat Director of the Coalition for the International Criminal Court, and also a member of the Washington Working Group for the ICC. And Jennifer Trahan is Clinical Professor at NYU Center for Global Affairs and Director of the Concentration in International Law and Human Rights at NYU, a convener Global Institute for the Prevention of Aggression, and I'm also a member of the Coalition for the International Criminal Court and the Washington Working Group for the ICC. Please join me in welcoming Enid Adler, Roger Clark, Liz Evanson, and Jennifer Trahan. So Enid, I would first like to turn to you. We're here to talk about the International Criminal Court, But there are several other courts, such as the International Court of Justice and others, that people might confuse with the ICC. So can you start by giving us a brief overview of the different key courts in The Hague, and then describe what is the ICC and how it came to be?
Hey, thank you, and good evening, everyone. Well, vive la différence, and that is to clarify first the major courts in The Hague that seem to create a little bit of confusion. So let's start first with the ICJ, the International Court of Justice, or also known as the Peace Court. It was created along with the United Nations back in 1945, and it deals with disputes between countries. And it also can offer advisory opinions. And many times we get a little confused with that one. Then in the 1990s, we had the situations in Rwanda and Yugoslavia. And so the United Nations Security Council decided that they needed what they call ad hoc courts to deal with the crimes created in both of those countries. And the point is there that the courts came into being after the fact. It's possible that a lot of evidence was lost. Witnesses disappeared. And so that became a problem. They were temporary courts and only to deal with those particular situations. And then we have the International Criminal Court, which began really, well, over many years. It's an outgrowth of Nuremberg. And then the Cold War intervened. But over the years, there have been various draft treaties, not draft treaties, but drafts that would become the treaty over time. Then after the wall came down in 1989, people started to think, well, maybe it's time that we have a permanent, independent, international criminal court to deal with core crimes that really rock the conscience of humanity, of people. So in the early 1990s, the Coalition for the International Criminal Court, which was composed of NGOs, which means non-governmental organizations, and they decided to, and also it was another name you can give it, is civil society organizations. There were about 300 at that point, and they decided to form an umbrella organization, which became the Coalition for the International Criminal Court. It was this coalition that pushed in the early to mid 1990s working with and getting to countries in the United Nations who were favorable, thinking about the possibility that this needs to happen. It worked, so that the coalition is really a partner with countries in the creation of this court. In 1995, there was a group formed to take a draft treaty from various places over the years and put it into some kind of form that would become the statute for the International Criminal Court. This then occurred in June of 1998 with the convening of the Conference of Nations. This would be the first treaty-based court ever, International Criminal Court. And so the coalition members, we had grown, I think, then to about maybe 800 members. We're now up to about 1,500 members. And worldwide, we convened in Rome for this treaty conference to formalize the draft of what would become the treaty, draft document in Rome. Now had 5 weeks to do this. And with that draft came over 1,300 either words or phrases in parentheses. They had all then to be worked out within those 5 weeks, which was difficult because everything was conducted in the 6 languages of the United Nations. And the discussions were really amazing. I mean, the compromises and the discussions over a word were quite remarkable. And there were a lot of compromises. This culminated in the crimes that we're talking about. It's the crimes against humanity, genocide, war crimes, and the crime of aggression. Now, the elements of the crime and the jurisdictional regime for the crimes were decided in Rome. However, there was no time to decide the crime of aggression. So that was to come in later under an amendment at the first review conference of the court, which was in Kampala in Uganda in 2010. On July the 17th, which was the final day, the treaty was passed, and the chair of the treaty meeting, Ambassador Philippe Kirsch, decided or made the determination that there would be no reservations allowed to this treaty. In other words, you take it or you leave it as it is. And others can talk about this. The United States wanted to add, of course, some reservations. As soon as you start doing that, you start watering it down. And when you start watering things down, you wind up with very little of substance. So it passed 120 countries. There were some abstentions because there were 160 that actually came to this conference, this meeting. And so that's and then following that, the court or the treaty, the court could not come into force. Now, this was the creation of the court. Let's get our date straight. This was July 17th of 1998. The court could not come into force until there were 60 country ratifications. And everybody thought it would take at least 10 years. Well, guess what? It happened in less than 4. In between, there were what were called preparatory commission, PrepComs, and I'll leave others to get into the nitty-gritty of those. But in April of 2002, we had our 60 ratifications. Actually, there were a few more. And the court came into force July 1st of 2002. Now, there's some things to know about this. Anything that was committed prior to 2002 was not admissible. It's not retroactive. And we have to also understand that when July of 2002 happened, there was no structure, nothing. So we had to basically, the court started from scratch. You had no judges, you had no home, no building, which the Netherlands, by the way, provided. Eventually, we got our own building, and which we have now. And so there was much to be put together. And in September of 2002, we had the first meeting of the Assembly of States Parties. Now, let me explain who they are. Okay, the Assembly of States Parties are like the legislative branch of the Rome Statute system. And they deal with the budget. They make other very important decisions. But that's where the countries that it's the Assembly of States Parties consists of the countries that have ratified the treaty, which now are 124. And it consists also, they're the ones that can vote and to make the decisions. Also attending are other countries who are not party to the treaty and observer countries, the United States being one. And then there's the coalition for the ICC. So that's the Assembly of States Parties, generally speaking. And the organs of the court, in other words, the court itself, you have the presidency, which is really the judicial branch. And under that, you have the 18 judges. And I have to just go back for a moment. The judges and the prosecutor and deputy prosecutors are all elected by secret ballot at the Assembly of State, by the Assembly of States parties. If necessary, if you ask me, I can talk a little bit more about that process. It's fascinating because there has to be, there's a whole geographical layout. Everything has to be equitable, geographic, gender, and equality and others as well. And you're also dealing with different legal systems, but the two major legal systems that really are part of the statute for the court are common law, which is the United States and the UK, for example, and related countries, and civil law, which is most of the rest of the world, including Europe and other countries as well. So you have the Assembly of States parties. And under the, I would go back to the presidency of the judiciary. So you have your 18 judges who are elected. Countries present their nominations, and then I think it was February of that year, of the following year, that we actually had the elections. And then you have under that the three chambers of the court: the pretrial chamber, the trial chamber, and the appeals division. And then you have the second group would be the office of the prosecutor. And the prosecutor and deputies, as I said, are elected by the Assembly of States parties. Now, before the election, and I want to go back just to make this clear. Before
I just wanted to just chime in. So before we get into more of the specifics on how they're elected, since you provided such a good overview,
well, I have to add one more part of it, though, the registry.
Okay, sounds good. And then I'm going to go back to Roger to talk a little bit more about just the drafting process too of the origins of the treaty, because I think it'd be interesting to get his experience as well.
No problem. Thank you.
Oh, do you want? Okay. So, we'll come back to you then to talk a little bit more specifics about, the organs of the court. So Roger, can you share a little bit more about your experience on the drafting committee? Enid just provided us a really great overview of the different kinds of courts and just a brief overview of the origins of the ICC, and just share a little bit about your experience behind the scenes of getting that treaty drafted and passed.
Thanks so much. I want to pick up on quite a bit of what Enid has said, but let me just correct, I wasn't part of the so-called drafting committee. I was there. I was there as a diplomat, which is a rather strange set of circumstances, which I should perhaps explain. I'm an academic lawyer, although I worked for the New Zealand Ministry of Foreign Affairs before I got into law teaching. But early in my career in New Zealand, I had a very smart student named Tuolani Namorini Slade, who was the first Samoan to attend law school. You'll appreciate that Samoan was a former German colony, which New Zealand administered for many years under the auspices of the League of Nations and then of the United Nations. Tuiloma, having graduated from my university, went back to Samoa to work for the government and became the Attorney General after a few years. We kept in touch. And by and by, he arrived in New York as the ambassador to the United Nations for the state of Samoa. And he called me up and he said, I need you to do some free work for me. He said, I don't have a budget for it, but I know you'd be happy to help. So one of the first things that he asked me to do was work on the negotiations for the International Criminal Court. And at the end of 1995, the General Assembly, largely on the prodding of the then president of Trinidad and Tobago, had started considering the question of setting up an international criminal court. There was a committee of the General Assembly looked at it, and I don't know, the way politics works is always fascinating. The committee decided that it ought to be a committee. So they pushed for the creation of what became the preparatory committee for the International Criminal Court. So early on in 1996, I went up to New York for one of the first meetings of this operation. And it soon became clear to me that just as Enid has pointed out, the importance of a court of this kind as piece of the architecture of international law for civil society, it was really important for little people like Trinidad and Tobago or like Samoa, which has about 177,000 people. If you don't have an army, and there are a lot of big and nasty people out there, sometimes all you have is the rule of law. And it was very important for those leaders in a number of those little countries to get involved in this enterprise. I wish I'd taken much better notes in the years that I was involved in this enterprise, but there it goes. All of it's arrived in New York, and I was invited along to a meeting of a group called the Like-Minded. And the Like-Minded were primarily Europeans, although Canadians were involved along with the Dutch, who were really pushing things along, and the Australians and the New Zealanders. And I took along Solomon Islands with me. Trinidad and Tobago was there. And I think there were 15 states that were there in January or so of 1996 who, as I say, called themselves like-minded, but pretentious for my taste. But there you go. They were the ones who were moving things along. Now, there was a draft out there which had been done fairly recently by the International Law Commission, which is sort of the law reform arm of the UN. And then people galore, states galore, put in various different drafts to go along with that. The Canadians put in a lot, the French put in a totally new one, the United States put in a whole, well, really a different draft, and so on. And some of the smaller states put in little bits and pieces here and there. And over the next 2 or 3 years, this gelled into an enormous draft, which used to be referred to as the phone book. It was this fat collection of alternative drafts for all sorts of things. The details of how the court would be set up, questions of what the crimes would be, and all those kinds of issues. Very, very controversial stuff. I'll confess that when I got involved in this enterprise, I thought it was very, very unlikely that it would succeed. I was wrong about that, and I was wrong in most of my predictions about where this whole negotiation was going to go. One of the key pieces of the enterprise, and one which is very hard to explain unless you've been part of this kind of negotiation, was that it was a negotiation that proceeded on the basis of getting a consensus. Really, until the very last minutes of the conference, we never took a vote on anything. There were assorted drafting groups of one sort or another, dozens of them over the years, from large ones to small ones, that pass up and down the chain as you get agreed upon language, and you slowly refine. And consensus often means, well, first of all, it means that you settle for something you don't quite like, but you know, the other guys don't quite like what they're getting either, and you can live with it. As I say, that was the very important part of the whole enterprise to get some kind of consensus. Now, very last minute, the very last evening, the United States broke the consensus and insisted on having a vote. I thought, frankly, it was very embarrassing for them to do. They got 7 votes as opposed to the 120 in favor of adopting the treaty and the 40 or so abstentions that happened there. Now, Enid hit the nail on the head, really, when she talked about 160 states and 6 languages. I mean, think about doing a negotiation like that. It's a very, very difficult enterprise. And in many ways, I was stunned that on the final evening of the conference, we actually achieved a pretty good treaty. And then, of course, a representative, a reporter from the Christian Science Monitor came to me and said, how long will it take to get the 60 ratifications? And I said, at least a decade, maybe not even in my lifetime, for heaven's sake. But it's a wonderful treaty. And of course, we did get the ratifications within a certain number of years. Just a final thought about the process, I suppose. Samoa, we were smart enough to get ourselves elected as one of the 21 or 22 vice presidents of the conference, which meant, as it turned out, we got assigned the task of negotiating the drafting of the preamble and the final clauses of the treaty. Now, I'll confess I'd never thought much about a preamble to a treaty, but a preamble is where you describe why you're doing this. And we had some enormously interesting discussions on explaining why it was useful to do this kind of enterprise, impunity, stopping future crimes of one sort or another, making the point there's some really bad stuff out there. And then the final clauses that came at the end, again, lawyers' eyes often glaze over at the thought of final clauses, but they had really important material in them, like how many states do you need to come aboard in order to make this a viable treaty? And we pushed for around 60, which is what we ended up with in the end, because we thought you needed a solid foundation. A lot of the NGOs were angry at us. They thought 20, 25 would do the trick. We thought you needed more than that. And then, of course, there was the important question about reservations, which was in those final clauses too. And we held out strongly on that position too. So I must say it was one of the most amazing professional experiences of my life. So I'm not a professional diplomat, but it was fascinating to do with it for those few years. And then go on to the other PrepCom, the preparatory commission that took place between 1998 and 2002, and then the exercise on the crime of aggression. And we'll come back to that later. If you give me just 1 minute, I'd like to make one extra point, and that is this. When Prime Minister and then President of Trinidad and Tobago, Arthur Robinson, put forward his proposal in the General Assembly in the late 1980s, what he had in mind was primarily a court that would deal with terrorism and drugs. Because from the point of view of a small country, it's a really difficult problem dealing with those issues. On the other hand, other states had a different concept of it as just being something that we deal with the really horrible things like genocide, crimes against humanity, and the crime of aggression. Again, from a point of view of a small country, have a really big terrorism or drugs case, you can blow out your budget, not just your justice budget, but the whole of the governmental budget on dealing with those kind of things. And it was important to them to move in that direction. Well, they lost out on the consensus on that. Well, I suspect that 40, 50% of participants would have liked a court which dealt with those kinds of things. The big players, on the other hand, the United States, French, Germans, and so on, said, no, we handle that just fine at the domestic level, and we don't want some silly international judges messing that kind of thing up. Well, and I've said, I think I've tried to give a bit of flavour of the negotiation and some idea of how we ended up where we ended up.
Great. Well, thank you so much, Roger, for sharing all of that, your experience and a little bit into the behind the scenes of how the treaty came together and your role in it. And also for setting us up with a little bit of insight into actually some of the crimes that are being addressed by the International Criminal Court. And so with that, Liz, I'll turn to you. So you've served on the coalition, which Enid told us a little bit about as well in her opening remarks. So if you want to say a little bit more about the work of the CICC, you know, its role in the formation of the court and the role it continues to serve, that would be great. And then if you want to get into a little bit more of the specifics of the crimes that the court actually addresses, which Roger kind of alluded to a little bit in the early negotiations in terms of what the court would cover, that would be great as well. And then we can maybe talk about some specific cases too.
Great. Well, thank you so much. And thank you, Lana, and thank you to the organizers for putting this discussion together. It's really great to be here. And I wanted to start by connecting to something that Mary Day said at the beginning, which is, I really think we're having this conversation in a moment of a lot of contradictions. On the one hand, we've gone from this foundational process that Enid and Roger have described so well in 1998, leading up to the ICC actually opening its doors in 2002, 2003, to now, not only do we have the law of the treaty, but we have a functioning institution. What the Rome Conference did was not only kind of codify the law, but it actually, you know, set up a court, set up an institution, set up a system, which is now working in 16 different countries. It has investigations in every part of the world. And I really, I only came into this work in 2008, so a decade after the Rome Conference. But everyone tells me, and the others on this panel could confirm it, that I don't think anyone expected that so quickly we would be where we are with this incredible instrument that the International Criminal Court represents. So full of potential, but the contradiction is the International Criminal Court, on a very cyclical and very predictable basis, faces efforts, you know, to stop its work in its tracks. And that's precisely because of what it's trying to do, which is to communicate, as Roger said, the power of the rule of law, and that rule of law applies to everyone equally, and that no one is above the law. And it's precisely because this is an institution and the community around the institution that's trying to deliver on that promise of victims' access to justice, that we're constantly facing retrenchment on the commitment to the system and constantly having to replenish the political will that is as necessary to justice as, you know, the law itself is. And I wanted to start with that because I think, to me, it does really epitomize the role of civil society, particularly in this, what I think is really well described as a community. There really is a community around the International Criminal Court and the broader system that it represents, because the International Criminal Court has been set up to be only a court of last resort, meaning the primary responsibility for dealing with these crimes, war crimes, crimes against humanity, genocide, aggression, lies with national authorities. And the court can only act under its treaty if national authorities are not. And so it didn't just set in place one institution in the form of this court based in The Hague. It actually set in place a system where the national courts of all of the countries that belong to the International Criminal Court should also be working. And around this system, there is just really a very tangible and viable community to this day. And I think that comes out of the experience leading up to the Rome Conference in 1998 and afterwards, where there has been a really unique partnership between states on the one hand, so the diplomats that Roger was mentioning, civil society campaigning for justice, and then also, of course, the actors within the justice system. So whether those are national authorities or the officials of the International Criminal Court. And one of the challenges I see going ahead is that, you know, as we get further and further away from that moment in Rome in 1998, how do we continue to replenish the values of this community? And I was really struck by what you said, Roger, about that emphasis on consensus and how that is still with us today, for better, for worse. The states parties around the ICC, as Enid said, they get together, they make important decisions, they hold elections, but the only votes they really cast to this day are in those elections for judicial officials. And even that, you know, they prefer to elect some of the officials, like the prosecutor, by consensus until very recently. And, you know, obviously insisting on consensus does mean compromise, but it also kind of does create kind of a certain spirit, a certain ownership. And I don't think that states parties should be afraid to vote at some point, but there are these kind of values and norms that came from the law creation moment that are still with us in this community. And another one of those values was to give civil society a seat at the table. And in Rome itself, civil society worked really closely with different delegations to provide advice on the treaty, to provide views, to try to make the treaty as victim-centered as possible, to try to make sure that this would be an institution that could connect up with the lived experience of the victims and the affected communities who would be looking to the court for justice, and that those affected communities would be heterogeneous, and some of them would be also looking to make sure that the court was signaling the highest standards of, you know, the administration of justice and fair trial rights, because perhaps, you know, they're affected communities, but they may also be supporters of people that would find themselves in the dock. So civil society was kind of given a seat at the table in the negotiations, and that has stayed true up until now, where there is a lot of back and forth between organizations like my own, Human Rights Watch, as well as in the broader constellation of the Coalition for the International Criminal Court, where, you know, I think our input is really valued by states, and there's sort of an understanding that for this system to work, it takes so many different actors to come together. It takes states to stand by their international obligations. It takes civil society to call those states to account, to stand by those obligations. It takes civil society to bridge the tremendous distance between these lawmaking processes and justice processes that are in, say, the global capitals, in New York, in Geneva, in The Hague, and the lived reality of where victims may be, which may be, you know, at this point before the court, anywhere from the Philippines to Venezuela, and sort of everything in between. The Coalition for the ICC itself has been an incredible framework for bringing together global civil society, as Enid said. There are members, I think you mentioned 1,500 members. I'm not sure what the current number is, but we have members in 150 different countries. And it's gone from being a network that pushed to establish the court, that is now really working to make sure that that system works and works well for all victims. And there's a tremendous amount of knowledge and expertise and resource sharing between the different groups in that coalition, even when it comes to not just around the International Criminal Court itself, but groups that are working on processes of accountability in their own country. For example, today, there was an incredible verdict delivered in Guinea in West Africa, 15 years after a massacre took place there. And civil society in Guinea has pushed to have justice nationally. The International Criminal Court, which could have taken up jurisdiction, actually has supported the Ghanaian authorities in taking that case. And that experience in Guinea, I know, will be channeled to groups that are seeking to have a similar process in their own countries. So it's a network of solidarity. It's a network of expertise. It's a network of information exchange. And it, you know, really sits into that place between where the law is and where, you know, where justice gets delivered. There's so much that needs to be moved to constantly remind states of their responsibilities, to hold them to account, to make sure there's space and independence for these processes to go forward. And those are all elements of what civil society can bring to the table. And I just hope as the system goes on, you know, we're able to remain true to those values that led to kind of a really exceptional moment of international lawmaking back in 1998 of partnership, of coming together, of seeking the protection of the rule of law, not seeking to undermine it, and bringing that with us as we move into this place where now the court is fully operational. Lana, you said maybe to touch on some of the specific crimes. We've laid them out already, and I think this is kind of interesting because the preamble, Roger, you were talking about the preamble. The preamble calls these the worst crimes, and in the treaty, the crimes are war crimes, so violations of international humanitarian law that that amount to crimes. They are crimes against humanity, which are certain kinds of crimes like murder, rape, extermination, which are carried out in the context of an attack against a civilian population. And unlike war crimes, they can take place in conflict, but they can also take place without the existence of a conflict, but they have to be as part of a widespread or systematic attack against a civilian population. The crime of genocide, and also the crime of aggression. And that's what the treaty covers right now. And these are labeled as kind of the worst, the worst crimes in the treaty's preamble. And I think that reminds us that this is fundamentally, a human-made lawmaking process. And I often ask myself, like, well, who decided that these are the worst crimes? Because it may depend where you sit. There may be other crimes that feel that they also deserve kind of the imprimatur of a court addressed to them. And that, is the great kind of part that we have this incredible instrument, but it's capable of being amended. And, we don't know in the future what other, crimes there may be a need to define under international law, and that might come within the jurisdiction of this court. And to me, it's particularly exciting to think about kind of lawmaking in a period where not only is it not 1948, just after the end of the Second World War, and as many countries were still gaining their independence, but also it's not even 1998. It's somewhere down the line, 2028 or beyond. And where do we get to as a community globally? What does it look like to have more inclusive and participatory lawmaking? And then what is possible? But I would say that the court has more than enough on its plate for now. So I think as we lean in to being innovative and creative and making, what seemed impossible in 1998 possible, we shouldn't be limited by our own imaginations right now. But we need to also make sure that what we have works and is protected. And again, that we find ourselves with the system just constantly under threat from those who don't want it to do what it was set up to do, which is just simply to provide victims with justice when they're not able to get it at home.
Great. Thanks so much, Liz, for explaining the role of civil society and the origins of the ICC, its ongoing role, the importance of the input of civil society groups like your own Human Rights Watch, and all of the members of the CICC, and their role in, as you said, making the criminal court, victim focused and really putting victims at the forefront of really its work, on top of and alongside of what national courts are doing as well. And also for setting out the crimes too, and digging a little bit more deeply into those. So Jennifer, turning to you, as Liz just set out the various crimes that are currently, being addressed under the ICC. And as Eden noted, the crime of aggression came a little bit later. So can you say a little bit more again about the specific crimes, maybe explain a couple prosecutions as an example of the way that the court or these crimes have been prosecuted, and also digging into the crime of aggression, why was that added later, and what is significant about the crime of aggression that kind of set it apart from the other crimes?
Yeah, sure, thanks. So it's a great pleasure to speak here today. Thanks for inviting me. So examples of the crimes. Well, the first case, Thomas Lubanga, was about utilizing child soldiers. And I think it was an incredibly important case. To me, it was not just about the case before the court. I mean, they did reach a verdict, they convicted. But after that case is over, you actually see small boy units in CAR, in DRC, in Nepal, disbanding as a response to the case. So to me, it's not just what the court can do. And Liz talked about complementarity, what can be done nationally also. But in a perfect world, there's actually enough cases, you start to deter crimes. And that's actually the goal of this whole justice institution, that crimes aren't committed. And to me, that's really powerful. If child soldiers are being disbanded because their commanders have learned about accountability, and maybe they learned about command responsibility and they don't want to find themselves in court. Genocide is one of the crimes. The court hasn't, the court has limited jurisdiction. It's able to do cases if the crime is in the territory of a state that's a party to the statute, or a national. So it's not always able to do these cases. So we sometimes hit, and this is one of the limitations. In a perfect world, we would have universal ratification, really be a world court. But we hit frustrating situations like in Myanmar. We think there's been genocide against the Rohingya, but Myanmar isn't a state party. So the court can only do crimes that have spilled over into Bangladesh, and it's proceeding on those. Genocide is this particular crime trying to wipe out a part of or a whole of a covered group, a national, ethnical, racial, or religious group. It's kind of when, instead of targeting military units, suddenly it morphs into whole-scale targeting of perhaps another ethnic group. Crimes against humanity seems to be is charged a lot. And as Liz described it, these are kind of widespread and systematic crimes. There's a whole list of those, and the court's mainly been proceeding on those. The court also has a gravity threshold. So in addition to the judgment that these are the crimes to pursue, it's not going to take some of the weaker cases, some of kind of smaller crime instances. It's really aimed at high-level perpetrators and the worst crime scenes. And that's where it sometimes gets in political hot water, aiming at high-level perpetrators. You know, some say, oh, it's a politicized institution. I think there's no way it's a politicized institution. One of the things that I think is just so ingenious is when you look at the composition of the judges, like on a trial chamber or an appeals chamber, they're literally from all around the world. So, you know, how can you argue, and I'll make up the nationalities, you know, judges from Peru and France and Guatemala and Mongolia, you know, how do you argue, oh, that was, you know, they're all biased, like, you know, so I think that's just such a clever thing about the ICC. You asked about where's this crime of aggression from? So we've heard some of the history. I'm going to take us way back. It's actually, I think the aspirations behind the crime of aggression they come from way back in history, but at least in the 1800s. In the US and UK, we see these peace movements. We have an Austrian Countess, Bertha von Suttner, writing of the horrors of war, Henri Dunant, writing about them. And these lead into a early peace conference, 1899, 1907 in The Hague. And we have parallel developments trying to prevent going to war and trying to constrain war if it happens. So the first is jus ad bellum, the second is jus in bello. And we see this progressing. And first there's kind of the attempt, we don't want states to go to war. So you see the Covenant of the League of Nations, it only has a 3-month cooling down period. Please wait 3 months before you go to war. Really a response, I think, to how World War I started. We have a really seminal transition, 1928 Kellogg-Briand Pact, international agreement, states relinquish aggressive war. We all, of course, wish this were in place. It is in place, that it was implemented. The UN Charter has, at its very core, not committing aggression. It's Article 2.4 of the UN Charter, coupled with the permissibility of self-defense, but only self-defense, or if the Security Council authorizes enforcement. So that's kind of at the state responsibility level. But at Nuremberg, we have the transition that we also need individual criminal responsibility. And that's what the ICC is doing for all of its crimes. It's because otherwise you would go to the ICJ that Enid first discussed, and we do see cases at the ICJ, but they're going to result in did the state do something? So the ICC is individuals, and they started this at Nuremberg, or their traces earlier, but the decision, we need to prosecute individuals. We can't just say, okay, Germany committed these wrongs. We really need to pierce it and have individual criminal responsibility. And that is what the Rome Statute did in 1998, saying aggression is one of the crimes before the court. There were intervening legal developments. The General Assembly in 1974 defined what is aggression, because the Nuremberg definition is pretty minimal and circular. But at Rome, they didn't agree on the contents of the definition yet. So that went through a later negotiating process. First certain PrepCom meetings, then the Special Working Group on the Crime of Aggression, and then the review conference in Kampala, Uganda, and they agreed on the definition of the crime, adopted by consensus by all states parties. And then in 2017, they activated the jurisdiction effective in 2018. So the court can use this jurisdiction. But it's unfortunately a very limited jurisdictional regime. So I talked about some of the limitations on jurisdiction. Generally, you need a crime in the territory of or by the nationals of the state party, or the Security Council could refer it. It hasn't been very active in doing that. It's made 2 referrals, the situation in Libya and the situation in Darfur, Sudan, another one of our situations where we believe genocide was committed and hasn't yet been adjudicated as such. So we go through this separate negotiating process. We have the definition, gets activated, but jurisdiction is unfortunately kind of truncated in the process. It is in the negotiations both in 2010 in Kampala and 2017 in New York that is somewhat truncated. And it's quite ironic because the US leads the truncation in 2010, and the UK and France do in 2017. And if you reflect back historically, these are 3 of the 4 allies at Nuremberg. So now when the Russian Federation appears to have committed aggression, the court actually lacks jurisdiction. So again, this is one of the to-dos for the future. The statute is not written in stone. It can be amended. So there are proposals that we need to amend the Rome Statute's jurisdiction over the crime of aggression. If you watch the news, you see the harm that aggression has wrought to the people of Ukraine. And yes, the court is going to prosecute war crimes and crimes against humanity there, but no matter how many cases there are, whether at the ICC or Ukrainian national authorities, they're never going to pick up the totality of the harm. And the crime of aggression actually would even say that soldiers should not have to die in an illegal war. So they're victims too. So that's why in the Nuremberg judgment, they call it the supreme international crime. So the group I am commuter of, Roger is part of it, the Global Institute for the Prevention of Aggression, we have a proposal to amend the ICC's jurisdiction on the crime and harmonize it with the ICC's broader jurisdictional regime. This should be taken up in negotiations in 2025, so stay tuned whether we achieve this next year. Not really an ICC topic, but I will say some of us are in parallel working on setting up a special tribunal on the crime of aggression for the situation of Ukraine. Yes, it would be good to do this across the boards, but it might not get done in time to cover the situation of Ukraine. So we are still trying to set up an ad hoc tribunal there. So these are some of the future challenges. The statute can be amended. It has been amended. The aggression amendment came in 2010. And periodically additional war crimes have been added when gaps are found in the statute. They didn't have starvation as a war crime, using starvation in the context of non-international armed conflicts. So there was an amendment. So the statute is sometimes updated. But I think I'll stop there with that introduction for the crime of aggression. It's actually has quite old origins in the early peace movement. the aspirations I didn't mention behind the founding of the Covenant of the League of Nations, the aspirations behind the UN Charter. But I think the crime of aggression puts more teeth behind the UN Charter, because we all know the UN Charter basically, there are limitations, maybe the topic for another day, but the Security Council and its voting, basically if the aggressor state is a permanent member of the Security Council, they just veto any condemnation or any other measures, and the UN system is stymied. So the UN system, it has these impediments, and in that situation, then smaller countries that rely on the rule of law are neither protected under the Rome Statute system nor under the UN Charter system. So it is trying to fill in that gap. Thanks.
Great. Thanks so much, Jennifer, for explaining that early history, as well as the connection between the ICJ and the ICC. I know you touched on that a little bit. And so, we're hoping to go till about 8:15. So hopefully we can have another quick round from each of our panelists. And turning back to you, Enid, you had set us up by going over the different courts, and Jennifer provided a little bit more color into that relationship between the ICC and ICJ. We do have a couple questions as well from our audience members, which I think Jennifer addressed, but maybe Enid, you could just go into a little bit more detail. So Wendy Jordan asks, what if the ICC and the ICJ don't concur? Could a leader of crimes against humanity not be tried by the ICC while the ICJ sanctions a country? And then Larry Holman also asks the relationship of the ICC to the UN, if the ICC is an integral part of the UN. So if you could just maybe speak a little bit more about to the relationship of those courts.
Right. Well, first of all, the whole point was that the ICC would be independent of the United Nations. So no, it is not. Other than what it does have on an equal footing is a relationship agreement with the UN. And so that again, it was important for it not to be part of, as the other courts were. Also, I think just to continue a little bit more in context, I want to just add a few little things here. That the Philadelphia, since we're in Philadelphia, the Philadelphia Bar Association was the only U.S. city bar association to pass a resolution prior to Rome in terms of agreeing that this court should be created. And as a delegate to or as part of the coalition there, I took that resolution, made copies, and gave it out to every country and every CICC member. I think it was important to know that that's a little bit of part of our history. I'd also like to talk about the firsts that this court has. One of them is victim participation at trial. For the first time, victims actually sit at the table, or their counsel, they have a choice, and participate in the proceedings, just as the prosecutor would, or any of the others. Also, that this court has reparations. It's the first time a court has reparations, and they occur at the end of the trial, usually if the person is convicted in that particular situation country. And they also set up, as part of the treaty by a resolution, the Trust Fund for Victims, which is really unique. So that the Trust Fund for Victims has its own board, but sort of comes under the registry rubric of the registry. And they actually, in a situation countries, will go into communities and work to make people whole. If they need psychological help, if they need a new limb, and they provide the care for that. They also work with the local community in terms of, for example, women had to go out at the community during conflicts, and many of them were raped and brought that child back to the community, and both the woman and the child were ostracized, is to work with the community to bring them back and make them again part of the community. And I think that's such an important thing. So that's one of the things they do. The second thing is they're the ones that deal with reparations. There's also, when I say that or we've heard that the court is a victim-centered court, which it is. It's very important to know, however, that the fair trial of the accused is just as important as a part of the rights of the victims. They're two of the main pillars of the court. One doesn't necessarily erode the other. And the concept, of course, it's sort of been inferred, no one is above the law. And that means the presidents of countries, and you've seen that recently occur. I want us to also go back, if I may, to the Assembly of States parties. They're also the ones that set the budget. And this is a very, very, it's not just an important question, it's important to the functioning of the court. And there's never enough of a budget for the various parts of the court, which really keeps them from doing a lot of outreach and having the money necessary to take care of all the cases that they have. Because the registrar, for example, who is elected by the judges, by the way, there's legal aid, and there's also, for the first time, a criminal defense bar. And so he's responsible for security when people come to the Hague for family visits for the accused. And so there are many, many things that cost money. There's going into the community and setting up community programs to explain what the court is, what the expectations are, what they can do and what they can't do. And I want to just go a little bit, nobody's really talked about the ways that a case, one or two little parts came in, but the ways a case can come before the court. One is a referral by the state's parties, which is the main way a case gets before the court. Another is a referral by the United Nations Security Council that was already talked about. The third is proprio motu, which means it can be initiated by the prosecutor. However, there was a lot of concern in Rome about the prosecutor running amok and that there would be prosecutorial abuse and it would be a rogue court. So he has to get the approval before he can go on with his investigation of the pre-trial chamber, which is the 3-judge group of the court. And there is actually a fourth way, and it's important now, and that's that a non-state party can send a request to the registrar where that country accepts the jurisdiction of the International Criminal Court in a particular situation. And it's important because that's exactly the situation with Ukraine. In 2014, when Russia went into Crimea, they asked under Article 12 for the court to have jurisdiction over the situation, which they continue to have.
Great, Enid. I just want to jump in and make sure we get to hear from all of the other panelists before we have to wrap. And I think you set up the next question really well when you mentioned the role of the prosecutor. We do have a question from Jeffrey Laurenti, who asks about the evidentiary threshold required for the issuance of a warrant. I think in context of the current recommendation for the warrants to be issued with respect to Israel and Gaza. So Roger, can you maybe add to what Enid was saying about the role of the prosecutor and just kind of that process about how the arrest warrants are issued, and maybe just give us an overview of the factual situation of maybe both Putin and also what's going on with the recommendation for warrants with respect to Israel and Hamas.
Sure, it's not unlike the process in American or British courts where you have to reach a minimal probable cause, a sort of evidentiary threshold in order to get the pretrial chamber to issue warrants. It's kind of interesting that you mentioned the two cases, the one involving Russia and Ukraine and the current situation in Palestine and Israel. Generally speaking, the practice of the prosecutor when asking for a warrant is to do that secretly. You just proceed and nobody knows what's happening until the warrant gets issued in due course or doesn't, as the case may be. And that, of course, is what happened in relation to Putin and the Commissioner for Children, and more recently, the two military leaders of Russia who've been the subject of warrants. So the whole thing becomes public once the warrant gets produced. In the case of Israel and Palestine, the prosecutor unusually announced that he was applying for the warrants. What is not clear is at this point is what his evidentiary basis is, but it's pretty clear that he has in mind both war crimes and crimes against humanity allegedly participated by both sides in the particular conflict. The pretrial tribunal has authorized a number of amicus curiae briefs to be introduced into the proceedings, and one assumes that the process will take the next few months in order to get to the stage of issuing or not issuing a warrant, as the case may be. Rather a dramatic development on that front today, when one of the Hamas people who has been charged, Ismail Haniyeh, was assassinated in Tehran, presumably by an Israeli strike. Not exactly, I think, what the prosecutor was expecting to happen to one of his defendants. I think it's important there's no capital punishment in the ICC, but this is a pretty strange development. If I could back off just to one question that was raised, the propria motu power of the prosecutor. That was something that ultimately was a bottom line in the negotiation as far as the like-minded group was concerned. Our position was that the only way you can be sure that the prosecutor is going to be independent and go after all sides is if you give him or her the power to do that. And I'm not too upset about the fact that there was a backup that he had to go to the pretrial chamber in order to do that. But it really was an important part of the negotiation, and we got that result in there. The other question that was asked earlier is the question of the relationship between the ICJ and the ICC. And I think it's important to understand that there's no hierarchical relationship there. One, you go on a track and you get a result in a criminal case. The other, you go and get what's effectively a civil case. And I suppose in theory, it's possible that you get two different results, but I think it's very unlikely. I think these are both pretty sensitive bodies, and there's pretty much agreement on the rules that are applicable in both instances. So I think it's unlikely, but hey, it's theoretically possible. Just to conclude, this may be my last word on this. I disagree with Enid a little about how the relationship issue with the United Nations played out. Certainly early on in the negotiations, we argued on behalf of Samoa that what we should do here is devise a statute for the court, which would be added as an annex to the United Nations Charter, just the same as the statute of the International Court of Justice is added to the Charter, so that the ICC would be an organ, a judicial organ, but a criminal judicial organ of the organization. There were two problems with that. One was that amending the UN Charter, like amending the ICC statute, is no fun. It's a very difficult operation to go. And ultimately, you have to get to amend the UN Charter, the agreement of the 5 permanent members of the Security Council. And ironically, when it came to the ICC, some of the people who were very pro the Nuremberg prosecutions had soured on the idea that they really wanted a court that could apply to them. So it'd be difficult to get it through the UN Charter. But I thought actually the ultimate argument was a little much more telling than the problem of amending the Charter. And that was, who's going to pay for this? And it was quite clear from early on in this negotiation that Washington didn't want to pay for it. And the United States pays 20-some% of the UN budget. And there's no way they wanted to pay 20% of the ICC budget. So you spin it off and have it as a separate operation, and somebody else can pick up the tab. So that was another really important part of the negotiation that I don't know was always well explained in public. But thanks.
Great, thank you, Roger. Liz, I want to ask you about an op-ed that you wrote recently, which talks a little bit about some suggested reforms for ways to strengthen global justice. And you mentioned how this might also affect the situation in Ukraine and Israel and Gaza. So could you share a little bit about some of those suggested reforms, ways in which this might improve the current system, and just your thoughts on what the future of the ICC looks like in the next, next couple of decades?
Thanks. Well, I think what it really boils down to is one of the big challenges for the International Criminal Court and for the system of international justice, and I think you could go broader than that to international law, is that there is an obvious double standard that is at work, where there are barriers for some victims, and other victims there is more support in parts of the international community for them to access justice. So in many ways, this is, again, going back to what the ICC stands for. It's been said by, many on the panel already, but, it really is about, the rule of law and about no one being above the law. And there's really nothing kind of more anathema to those goals than, if the ICC itself is perceived as perpetuating double standards. And it's, I think not necessarily been the case that it's the court itself or the decisions of the court that lend themselves to double standards. It's one part, the jurisdictional regime, which others have already explained. This is a consent-based court. States have to join the treaty. If they don't join the treaty, they can also accept jurisdiction. The Security Council has a role, but largely we're talking about a court that is limited in its jurisdiction to those states who have accepted that jurisdiction. And while that's, grown in, I think, incredible ways, I mean, who would have believed that we'd be sitting here with a court that has active investigations in Ukraine, which doesn't belong to the ICC, but has accepted its jurisdiction, in the situation of Palestine, where the state of Palestine is a state party to the ICC. And we really see that, consent is it's not a null set, you can get there. But we still have a long way to go to have universal acceptance of the treaty. So that by its nature means that some crimes are going to fall outside of the ICC's jurisdiction. So it's not the institution itself per se that perpetuates those double standards, but it's the treaty that allows for states to opt out basically by not joining. It's the global political order that protects powerful countries from institutions like the International Criminal Court. It's powerful countries protecting their allies. And it's just become, I think in a good way, there's more and more discussion about these double standards. There's more discussion about how in the aftermath of the full-scale invasion of Russia in Ukraine, all of a sudden you saw, so many countries, particularly in Europe, coming forward and expressing support for the ICC in fact, even kind of opening up their pocketbooks and wanting to give more money to the ICC because of the potential to investigate in Ukraine and specifically to investigate Russian crimes. And those were many of the same states that, as Enid has said, for years have resisted giving the court an adequate budget. And because the situation concerned, obviously incredibly important and very welcome that those states supported the ICC's action in Ukraine, but because it was so directly connected to kind of a more narrow national political interest, whereas providing the resources for the court to be able to act across its whole global mandate was not as a priority. I think that set off a lot of more public debate and discussion about how we need to look at the system and we need to make sure that the system itself doesn't replicate or accept as inevitable double standards that could end up communicating that some victims have more priority than others. And so I think in terms of reform, it's really straightforward. It's really simple. It's all states should join the ICC. That would give then the court the ability to act wherever it finds the evidence. And as Roger went through in terms of the arrest warrant process, there are so many checks and balances built into this system. It's a slow process, which is so frustrating often to civil society, to victims and survivors, I'm sure to governments that are paying the bill. But that's partly because this is a system that, in its treaty really put in place a lot of opportunities to make sure that this court is dealing only with the cases that it's meant to be dealing with. But a way to give the court the ability to act as fully as it can within those safety measures, so to speak, is for all countries to join. We also have to look at the role that the Security Council plays. Yes, the court is independent of the UN, but the court depends heavily on cooperation, not just of individual governments, but also on UN cooperation. The ICC doesn't have its own police force. So how do you get arrests? You need help. And that help could come from individual governments, but it could also come from peacekeeping missions. So you need to have a UN that is supportive of the ICC, and you need to have a Security Council which isn't going to use veto powers to block the court from acting, when there are atrocity crimes. And then just kind of where I started in this answer is you need the resources. You need states parties to commit up to a budget that really allows the court to act wherever it's needed to act. That is how we will get to that deterrent effect that Jennifer mentioned, so that the court won't need to act. But until we get there, if the court is perceived as being too slow, not relevant, not where it needs to be, which are all criticisms from the last 20 years, oftentimes behind that, yes, maybe there's some political blockages, maybe there's some treaty problems, but there is also just the reality that it's one institution with about 1,000 people at this point trying to do investigations in 17 different countries. And until states are really willing to provide it with the resources it needs, unfortunately, it's going to make priorities and it's going to unfortunately kind of replicate some of these double standards in the system, which undermine confidence really in the legitimacy of the institution, in the legitimacy of the justice that it rendered. So both, for now and going into the future, I think it's great that we're hearing more about these double standards. It can be painful to hear because, we all want the system to succeed, but it's good to put it out there and to have a commitment from all of the different actors in this system to really, really challenge the inevitability of those double standards and work to break them down.
Thanks so much, Liz. Jennifer, the last word is to you, and a similar question, if you could just maybe add on to anything that Liz just mentioned in terms of some recommendations for ways to improve the functioning of the court in the future. I know you also wrote a piece digging more into suggestions to amend the crime of aggression amendments. So share any final thoughts you might have about the future of the court as well.
Yeah, thanks. Well, I think Liz laid out a number of the challenges, and in the United States, it really is an issue that we can't really pick and choose in terms of international justice. We saw, the prosecutor issue indictments related to Ukraine, and suddenly members of Congress who thought, the ICC is this evil institution, are suddenly championing it and praising the ICC. But then, the court, the prosecutor applies for warrants in Israel-Gaza situation, and we see a very different reaction. And You know, and it is kind of, you have to kind of support international justice and let the court go through its procedures. It has a lot of checks and balances. We've heard about some of those built into the system, and tremendous diversity in terms of the judges, the staff of the court. But unfortunately, the US has really wanted to, you know, maybe support this case and support that case, but not support the others, and in fact put sanctions on people or the prosecutor who do. So I think the US has to mature in terms of the field of international justice. The US was always very supportive when it came to the other tribunals, but before them, frankly, we knew that it would be people of, you know, Rwandans or Yugoslavians or Sierra Leoneans who were prosecuted. Well, the ICC has broader potential. So I think the US needs to significantly evolve in its relationship with the court. Just in terms of the future, I will highlight one of the areas Roger and I have worked on is cyber as an element of the Rome Statute war crimes. We were part of a group called the Council of Advisors on the application of the Rome Statute to cyber warfare. And we did like a 100-page report that basically said cyber is kind of a new way that the crimes are being committed. And you don't need a Rome Statute amendment. It's just like a computer isn't a weapon system, but it can be used like a weapon system. So, you know, we don't need an amendment. It's just inherently there. And I think after our report, we were really encouraged that the prosecutor agreed and said, yes, cyber is kind of a modality by which the crimes are being committed. And the prosecutor OTP is going to issue a policy paper on this topic. So I think this will be an important new development. We're not talking cyber crime. There's a huge amount of cyber crime. It's more like, you know, really contributing to genocide. And I'll just give one example because I know the hour is late, but in the genocide against the Rohingya, the incendiary posts kind of drumming up hatred were posted on Facebook. So we have media that unfortunately have huge potential new mediums to incite genocide. So to me, that is a cyber-enabled genocide. We look at Chinese surveillance against the Uyghurs you know, pulling content off their iPhones, facial recognition technology, robotic birds, all kinds of methods used to track what we believe also is a genocide. They're unfortunately beyond the court's jurisdiction. So these are probably where the court's going to go in the future. We haven't yet even figured out the potential of AI to be part of the crimes, but I'm afraid we're also going to need to go there. We may have AI-enabled war crimes in our future. So this is kind of, I think, where the court will go in the future. And I hope it will really go in the direction that Liz discussed about and I think all of us support, every country joins the ICC, it will truly be a global court. And that was the vision that when it was initially created, they wanted a court that would have jurisdiction over every country. We're not, and the ICC probably has jurisdiction over maybe 2/3 of the globe, or maybe less. It's not universal. So there's some horrific atrocity crime situations that are right now escaping jurisdiction. So I think these are the challenges for the future.
Thank you so much, Enid Adler, Roger Clark, Elizabeth Evanson, and Jennifer Trahan for joining this evening, for sharing your insights into the background, the workings of the International Criminal Court, as well as where it's headed in the future. Thank you all for joining us this evening, too, for submitting your questions. And to close us out, I'll turn things back over to Mary Day.
Thank you. I can hardly say how excited this has been a terrific opportunity to learn. Even those of us who like to think that we follow these things, there's so much that I didn't know that I learned tonight. I do want to add to the thank yous. Thanks, Lana, for your help in coordinating this and keeping us balanced and on time. thank you to Jennifer New and Bob Moore from the Coalition for Peace Action for providing outreach and technical support, without which this would not have happened. And I do want to make just a pitch for future things coming up. If people on our audience are not members of the United Nations Association, please go to the UN Association, UN USA, and look into being a member. And they give you a chance to say which branch you'd like to participate in. And we'd love to have you be part of Philadelphia. And likewise, the Coalition for Peace Action has a website, peacecoalition.org, and they are organizing a commemoration on August 5th of the nuclear bombings in Japan, and would very much like to have people participate in that. And I think with that, we thank you, and we can go watch the Olympics.
Thank you.
Thank you.
Thank you all. Bye-bye.